All right, good morning, everyone. I'm Judge Corey Amanda Cawthon, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. Remember that today is not your trial date, and I do encourage you to speak with your attorneys before speaking on the record today, because everything that we say here is being recorded and can be used against you at a later date. For those of you represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present here in the courtroom with me and are available to you by phone. For those of you represented by private counsel, know that your attorneys also come here to the courtroom with me and are able to address your cases from here. If your attorney is not in the courtroom when I call your name, you can let me know that, and we will see how we can help facilitate that process for you. However, I ask you not to tell me that you have private counsel unless you or your family have already retained counsel for this specific arrest. You also need to know that this morning I have in the courtroom with me attorneys from the State Attorney's Office, as well as representatives from Confinement Status, Pretrial Supervision, and the Clerk of Courts. All of these persons are here to help facilitate this morning's session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here at first appearances if you are here on misdemeanors or municipal ordinance matters, but understand that it's dependent on what is going on with you personally and with your case. For those of you present this morning on felony matters or violations of probation where the judge has already set a no bond hold, know that those cannot be changed or resolved here at first appearances. Following today's hearing, your case will be assigned to a specific division judge, and going forward, all pretrial motions and any subsequent trial will be heard before your division judge. As we are getting started this morning, I have 3 cases to be called out of turn from the jails. I'll go to those cases first, and then I will go to our sign-ins. To begin, I have 1 case at Paul Ryan on page 6, and that is for Serena Brooks. All right, thank you. All right, good morning, Ms. Brooks.
Good morning.
Ms. Brooks, you're before the court this morning on 5 charges. Count 1, possession of a controlled substance without a prescription. Count 2, possession of cocaine. Count 3, possession or use of drug paraphernalia. Count 4, resisting an officer obstructing without violence. And count 5 is trespassing of an unoccupied structure or conveyance.
Okay.
All right, I find probable cause. And Ms. Brooks, Mr. Miller is acting as your attorney this morning. He's here in the courtroom with me. So just listen for a few moments while I hear recommendations from the parties. Is the state seeking anything beyond the standard bond?
No, Judge.
All right, Mr. Miller, I'll go to you.
Judge, we're seeking a release on recognizance for this case. Ms. Brooks is from Tampa. She was visiting here for about 3 weeks, and she cannot afford to post bond. She's visiting here for 3 weeks. I'm curious why she has Broward Outreach Center as her address. I know that's what she's telling you. Doesn't sound right to me.
Does she have priors?
I'd have to run her in the system.
Okay. Ms. Brooks, where do you live?
Nowhere.
Okay, so are you residing in South Florida right now?
Yep.
Okay.
She had a recent arrest in January of this year for paraphernalia out of the state of Arizona.
November of last year for trespass in California was sentenced to 45 days in county jail. Just finding a way to make it to opposite ends of the country.
Okay. All right, Mr. Miller, based on the information that's being provided to me, I'm not comfortable with a straight ROR, but I'm willing to hear another recommendation if you have one, based on your conversation with Ms. Brooks.
Judge, I've pretty much given you everything I have. She's not gonna make pretrial.
Well, I'm willing to release her without a monetary bond, but it's gonna be to pretrial supervision with random testing.
Ms. Brooks, can you comply with requirement that you report to pretrial services and give them random samples of your urine?
And where is that gonna be at?
Downtown Fort Lauderdale.
Yeah, no, I don't even know where that is. Like, I'm not from out here. I'll be on the streets if y'all let me go right now. So I don't even know how to report to anywhere. Y'all get me picked up and take me there, sure.
All right, I'm gonna leave the standard bond in place in Ms. Brooks's case at
Thank
this
you, Judge.
time. Thank you. All right. Yes.
You done?
All right, thank you, Ms. Brooks. All right, next we will go to Maine. I have a case for our Spanish interpreter who is present. That is Santos Saravia on page 14. Thank you, Deputy. And for my interpreter, will you please raise your right hand? Do you swear or affirm to interpret from Spanish to English and English to Spanish to the best of your ability?
I do. I give us con interpreter.
Thank you. Good morning, Mr. Saravia.
Buenos días, señor Sarabia.
Sí, buenos días.
Yes, good morning.
You're before the court this morning on an ad charge.
Está aquí ante la sala del tribunal esta mañana por un cargo agregado.
This is an immigration hold.
Es una petición de detención de parte de inmigración.
I find probable cause.
Dictamino que existe motivo fundado.
And Mr. Saravia, this has a no bond hold, which means you will go before an immigration judge to address this matter.
Y señor Sarabia, esta detención es sin fianza, o sea que significa que va a tener que ir ante un juez de inmigración para abordar el tema de este cargo.
Good luck to you, sir.
Suerte, señor.
All right. Before I go on, is there anyone else at the main courthouse that requires a Spanish interpreter?
Two people, Judge.
Okay.
The first gentleman is on page 5 of the court's docket. No, she is on page 5, Carol Aguilera. And
Okay.
the other individual is on page 9, and his name is Mr. Santos Blanco Melendez.
All right. Good morning, Ms. Aguilera.
Buenos días, señora Aguilera.
Buenos días.
Good morning.
Muy buenos días.
You're before the court this morning on one charge of first-degree grand theft.
Está ante el tribunal esta mañana por un cargo de hurto mayor de primer grado.
I find probable cause,
Dictamino que existe motivo fundado.
and I will hear from the parties.
Escucho de las partes.
Judge, in speaking with Mr. Lender earlier today, I believe we have an agreement. I believe Mr. Miller also spoke with Mr. Lender as well. I believe the state is okay with either having a release in her supervision with pretrial or giving her a monetary bond. One moment, Judge.
Entiendo que he hablado con el señor Linder de la Fiscalía y entiendo que el señor Miller también ha hablado con el señor Linder de la Fiscalía y creo que hemos llegado a un acuerdo de que haya libertad provisional bajo régimen probatorio con la libertad provisional o con una fianza monetaria.
Your Honor, Mr. Miller approached me and asked me if I'd have an objection to release the pretrial or ROR.
El señor Miller se me acercó y abordó el tema y me preguntó si yo tendría alguna objeción a que haya libertad provisional.
It's my impression that Ms. Aguilera could not afford a bond. That's why the request is being made.
Era mi impresión que la señora Aguilera no podía costear el pago de una fianza, por eso se hizo esa petición.
I wouldn't normally, with a case like this, agree to an order of pretrial based on the amount of the value of the property.
Yo normalmente no estaría de acuerdo con la libertad provisional en un caso de esta índole.
Mr. Romero approached me and asked me later if I'm okay with the $2,500 bond.
El señor Romero después se me acercó y me preguntó si yo estaría dispuesto a dar una fianza de $2.500.
Given the circumstances we find ourselves in, I would not have an objection to a $2,500.
Dadas las circunstancias en las cuales nos encontramos, yo no tendría objeción a una fianza de $2.500.
Without the pretrial requirement?
Yeah, it's just a straight bond release.
And Judge, I spoke Ms.
Con la
Aguilera.
libertad provisional, sí, una fianza directamente y libertad.
Her boyfriend, who works in construction, she believes can come up with, using the services of a bondsman, can afford $2,500. So that's what we're going to be asking for, Judge.
Y su señor, yo hablé con el novio de la señora y él trabaja en la construcción y él podría costear los servicios de un fiancista con una fianza de $2.500.
All right, based on the parties' agreement, the bond will be set at $2,500.
Ok, basado en el acuerdo acordado entre las partes, la fianza va a ser fijada en $2.500.
There will also be an order of no victim contact.
También va a emitirse una orden de no tener contacto con la víctima del caso.
Ms. Aguilera, whether you know the alleged victim or not,
Señora Aguilera, aunque usted conozca a la víctima o no la conozca,
this order means no being in the same place at the same time as the alleged victim,
esta orden significa que no se puede encontrar en el mismo lugar a la misma vez con la alegada víctima,
no phone calls or text messages to this person,
no puede llamar por teléfono o mandar mensajes textos a esta persona
and no third-party contact or social media contact with this person.
y con esta misma persona no puede tener contacto a través de terceras partes o a través de los medios sociales.
Do you understand that, ma'am?
Señora, ¿usted entiende eso?
Sí.
Yes.
All right, thank you very much.
Muchas gracias.
Okay. All right, and next will be Santos Blanco Melendez.
Próximo, Santos Blanco Meléndez.
Good morning, Mr. Blanco.
Buenos días, señor Blanco. Good morning.
You're before the court on one charge of aggravated battery where offender knew or should have known the victim was pregnant.
Está ante el tribunal por un cargo de agresión, lesiones agravadas. El imputado tendría que haber conocido o sabido que la persona estaba embarazada.
This is domestic violence.
Esto es un caso de violencia doméstica.
I find probable cause,
Dictamino que existe motivo fundado
and I'll hear recommendations from the parties at this
y
time.
abrirá la sala para escuchar recomendaciones de parte de las partes.
One moment, Judge.
Un momento, su señoría.
Your Honor, the state would be seeking a $7,500 bond and an order of no victim contact.
Su señoría, la fiscalía estaría peticionando una fianza de $7.500 y no tener contacto con la víctima.
While Mr. Blanco Melendez has no criminal history,
What was it? How much was the bond?
$7,500.
La fianza era de $7.500.
While Mr. Blanco Melendez has no criminal history,
Ya que el señor Blanco Meléndez no tiene antecedentes,
this is based on the victim's physical condition.
esto es basado en la condición física de la víctima.
Additionally, our office had contact with the alleged victim.
Adicionalmente, nuestra oficina tuvo contacto con la alegada víctima.
She advised us she is in great fear of Mr. Blanco Melendez,
Ella nos informó que le teme mucho al señor Blanco Meléndez,
that there has been previous violence in the relationship.
que ha existido violencia previamente en la relación.
Specifically, he has threatened her in the past with a machete.
Específicamente, él la ha amenazado en el pasado con un machete.
Nothing further, Judge.
No tengo más, su señoría.
All right, Mr. Romero, I'll go to you.
Señor Romero, ¿a usted?
Judge, I had an opportunity to speak to Mr. Blanco Melendez. He's not going to be able to be released with the $7,500 bond.
Su señoría, yo tuve una oportunidad de hablar con el señor Blanco Meléndez. Él no va a ser capaz de provisionar la libertad con una fianza de $7,500.
He simply is not going to be able to afford it.
Simplemente no va a poder costearlo.
Now, he did want me to ask the court for a phone order so he can try and contact coworkers to try and see if they can be willing to help him out by posting his monetary bond.
Ahora él sí peticionó que yo le requiriera o le peticionara al tribunal una orden para tener acceso a su teléfono para que él pueda contactar a sus colegas de trabajo para ver si ellos podrían juntar el dinero para pagar la fianza.
Now, once he's gets the phone number and is able to contact this coworker, he believes his coworker has limited funds as well.
Ahora, una vez que él pueda contactar a su colega de trabajo y pueda hablar con él, él sí cree que tiene fondos limitados o
Yeah.
ingresos limitados.
They do work in landscaping, Judge.
Sí trabajan en jardinería, su señoría.
He's been doing that for the past 6 years.
Ha estado en ese trabajo los últimos 6 años.
Things are going well. When there's work and everything like that, he makes approximately $450 a week.
Ahora, cuando hay trabajo y las cosas van bien, está haciendo aproximadamente $450 a la semana.
Now, in my conversation with him, because of the crisis we're living in, he thinks his hours are going to be significantly reduced and there's not going to be enough jobs out there.
Ahora, con la conversación que he tenido y con la crisis que estamos teniendo ahora, él piensa que las horas van a ser reducidas drásticamente y que no va a haber demasiado trabajo.
So the person he's going to be contacting also works with him as a coworker, so he believes his hours are going to be reduced. So whatever savings or anything he has, he's going to have to hold on to it to try and help him like storm through this crisis we're living in.
O sea que esta persona que es un colega de trabajo de él, cualquier recursos o ahorros que él tenga, él piensa que los va a tener que guardar para poder vivir a través de esta tormenta que estamos viviendo actualmente en la sociedad.
Believes that maybe his friend can come up with about $2,500 bond. So that's what we're going to be asking for at this time, Judge.
Él piensa que quizás su amigo pueda juntar para una fianza de $2,500 y eso es lo que vamos a estar pidiendo en este momento, su señoría.
Now, since this is the first time he's been arrested, I did explain to him, as far as the no contact order, that he's not going to be able to have any sort of contact with the victim. And he did advise me he understands and he will be abiding by that.
Ahora, ya que esta es la primera vez que él ha sido arrestado, sí le expliqué que va a existir una orden judicial de no tener contacto con la víctima y él entiende eso y él va a obedecer esa orden de no tener contacto.
Nothing further.
No hay más, su señoría.
The bond will be set at $5,000.
La fianza va a ser fijada en $5,000.
Mr. Blanco Melendez, there will be an order of no victim contact.
Señor Blanco Menéndez, sí se va a emitir un decreto judicial de no tener contacto con la víctima.
This order means no being in the same place at the same time as the alleged victim.
Esta orden significa que no puede encontrarse usted a la misma vez en
That
el mismo
also-
lugar con la víctima.
That includes no phone calls or text messages to this person,
Eso también incluye no tener contacto telefónico o a través de mensajes de texto con esta persona.
and no third-party contact or social media contact with this person.
Y también no tener contacto a través de terceras partes o a través de los medios sociales con esta persona.
Do you understand that, sir?
Señor, ¿usted entiende eso?
Sí.
Yes.
All right, thank you.
Gracias.
Okay, is there anyone else at Maine that requires a Spanish interpreter?
¿Alguien más en Central que requiera servicio de intérprete en español?
Not that I'm aware of. I don't know if the deputies have found anybody else who needs the services.
Deputies, anybody else at Maine? All right, thank you. Anyone at Paul Ryan, Conti, or North Broward that requires a Spanish interpreter? All right, thank you. Come on up, I'll sign it. Okay, my next case to be called out of turn is Albert Marquez on page 15 at Maine. Good morning, Mr. Marquez. Mr. Marquez, you're before the court this morning on 6 charges. Count 1, battery on an officer, firefighter, or EMT. Count 2, touch or strike battery. Count 3, assault. Count 4, resisting an officer obstructing with violence. Count 5, resisting an officer obstructing without violence. Count 6, trespassing on an occupied structure or conveyance.
No, ma'am.
Sir, We spoke, this is Hector Romero, we spoke on the phone. Today's not a time to talk about the facts of the case. I'm going to make my argument to try and see how we can get you out. You'll have a day in the future to fight these allegations. Today's not the day, okay?
Yes, sir.
Thank you.
All right, okay. For the record, I do find probable cause, and at this time, I will hear the parties' recommendations.
Your Honor, first off, the court should be aware. Yes, ma'am. Your Honor, the information that I have and that pretrial release services has is this man's name is not Albert Marquez. His name, according to the state of California, where I'm showing is where he resides, is Carlos Maestes. He has, from what I can tell, a very lengthy history out of the state of California. One moment. Showing 2017, threatened to commit a crime with intent to terrorize. (2016) same offense. Obstruction. Battery against a police officer, 2015. Obstructing a police officer, 2015. See a failure to appear from 2014. Your Honor, frankly, I mean,
It's
I'm
all
not,
misdemeanor.
I'm not even close to half done with this history out of the state of California.
All right, just give me your recommendations.
Yes.
Oh, I'm sorry.
Your Honor, I'd be recommending a $2,500 bond on count one, a $500 bond on count four.
All right, thank you. Mr. Romero?
Judge and speaking, Mr. Marquez, he informed me he has a record. He just, he was up front with me. He told me he just arrived from California. And right now, unfortunately, he's financially indigent. There's no one he can contact to help post a monetary bond. He owns no sort of property. He's 51 years old. He gets disability, approximately $800 a month. But there's no one he can contact. Now, we're going to be asking for a photo order so we can photograph the injuries he sustained. But as far as his financial resources, there are none. So we were going to be asking the court to release him on pretrial release. I did talk to him a little bit as far as what pretrial entails. I believe in speaking to him. He will be able to abide by that, but financially he can't afford anything.
And I would just know, Your Honor, I don't know how much what he has advised Mr. Romero of can be taken at face value, considering this isn't his name, and also the claims he made to law enforcement about his physical condition that were later proved not to be true.
To begin, I will sign the photo order. While I understand the information that's been provided to me as well as the present circumstances that we all find ourselves in, I am concerned with the level of violence that's alleged in this probable cause affidavit. The bond on count one is going to be set at $1,000. The bond on count four will be set at $250, and I'll leave the other standard bonds in place. There is going to be an order of no return to the Greyhound bus terminal that's at issue in this case. So, Mr. Marquez, that means that you're not to return to that location. And there will be an order of no victim contact. From what I'm reading in the probable cause affidavit, and Mr. Linder, you can correct me if I'm wrong, I do see that there was a security officer and a law enforcement officer involved, but there's also what appears to be a civilian alleged victim in this case.
Yes.
All right, so Mr. Marquez, whether you know that person or not, the no victim contact order means no being in the same place at the same time as that individual. No phone calls or text messages to that person, and no third-party contact or social media contact with him. Do you understand?
That's fine.
All right, thank you very much, sir. All right. And before I go on to our sign-ins, Mr. Miller, the one case that we needed a Russian interpreter for, are they going to be able to get somebody for the morning, or is that going to have to be for the afternoon session?
Judge, I've been in contact with the interpreter's office. They're advising me that the Russian interpreter is going to appear by phone.
For the morning session?
We can call anytime. I've advised my supervisor of the situation. I think this is an unacceptable response. I believe my client has a right to have an interpreter present. We tried it yesterday afternoon and it was problematic.
You advised them yesterday afternoon you were going to need someone?
Yesterday afternoon, we had the Farsi interpreter,
Okay,
and it was done over the phone, and it was cumbersome and problematic.
okay.
So I'm not sure why they're giving us a hard time. We've established that they're going to be given admittance to the courthouse in order to
Correct.
conduct these hearings, but we're not getting any cooperation from the interpreter's office.
All right. Does the state have a position on this at all?
Honestly, I've given this some thought since yesterday, Judge. Frankly, in the situation we find ourselves in, if we can get something done without someone being here, if it can be done by over phone, I think that's fair. I don't think it's fair. I don't know that there's a right to have an interpreter present in the courtroom. We had a case with an interpreter yesterday that we got done over the phone. But you know, we talk all morning about the climate we find ourselves in. I don't think it's necessarily fair to require someone to come to actually physically be present if we can get the job done over the phone with them.
The issue that I see, besides the fact that, you know, sometimes it's obviously difficult to have people over the phone, is that this is an individual who has to be sworn in. And to do that telephonically, I'm not sure that, if it was via video like we do here with the jails, that's a different situation than doing over the phone.
And I would agree with Your Honor, except for the fact I think the court can have an appropriate level of satisfaction considering you'd be calling the number that was Mr. Miller reached out to court administration, to the interpreter's office. This interpreter reached out to him, provided the phone number. It wasn't like a random person contacted Mr. Miller. It was in response to his request through the interpreter's office.
Okay, let's do this, because I foresee, at least for the present time, that we might have this issue come up more than once. So I would like to get some direction from the Chief Judge's office on how we're gonna handle these for all of our future proceedings. So let's, this is for Archer Gregorian. Let's reset him on the PM docket, and I will get a directive from the Chief's office, and then we'll figure out what we're gonna do, and that will obviously be communicated to the Public Defender's office and to the Interpreter's office. That's fine. You can do that. That's fine. All right. As long as, do me a favor and put, if Mr. Linder's not on that chain, make sure he's on there as well. Yeah. I'm sorry? It's Gregorian? Yes, Archer Gregorian. He's on page 8. Will be reset to the PM docket. All right. All right, I'll handle that before I leave. Session. Okay, ladies, will you hold that for Judge Lerner? Thank you. All right, so now we're gonna go to our sign-ins. First up, on page 7, Joseph Giltinan, his private counsel, Mr. Cohen, is present in the courtroom.
Yes, Judge, good morning.
Good morning.
Can you hear me through the mask, Judge? I just want to make
I
sure.
can hear you. Just
Okay.
try to speak loudly into that microphone.
I don't want Mr. Gilton to be upset by the mask, Judge.
All right, good morning, Mr. Giltinan.
Morning.
All right, Mr. Giltinan, you are before the court this morning on a violation of probation. This is a no bond hold and a misdemeanor case. I find probable cause. And Mr. Cohen, do you wish to be heard?
I do, Judge, I do, and I know something about this because I handled the underlying case, and I filed notices of appearance already both in the Orange County case and in this case as well.
Okay.
Mr. Gilton is from Pennsylvania.
All right,
He has 2 boys with the victim, I believe, 14 and 8 years old, as I understand it.
all right.
They've been together a long time. She has a history of starting fights with him, having these matters come to the police, and then not being interested in going forward with the prosecution after this takes place. If you read the probable cause affidavit growing out of the Orange County case, they were on vacation. Apparently, she claims that he hit her, he claims that she attacked him first after they went down to a bar and had some drinks. So there's no independent witnesses in that Orange County case, Your Honor, and I very much expect that she will not prosecute this case when it comes down to it. In view of that, Judge, I'm just asking the court consider a bond at this particular point. There's already a no-contact order out of the Orange County case,
Okay,
and Your Honor could issue a no-contact order here, and RORM, I think the main issue for concern would be the no-contact order, quite frankly. I don't think there's any issue otherwise, apart from that, Judge.
okay. State, do you wish to be heard?
Your Honor, I would say we will leave this for Judge McHugh. She did sign the warrant issuing a no bond hold. I do also want to state that it is the same victim on the underlying violation case and the new case that he picked up out of Orange County. So we would argue that it should be heard in front of Judge McHugh since she is the one that held the no bond hold.
Yes, Judge, and that plea in the underlying case, which is the underlying case for the now probation violation, the same set of facts, the same situation, Your Honor. Again, she didn't want to prosecute at that particular time. It was a plea of convenience because both she and he live in Pennsylvania. So rather than coming down, he wanted to save the money. It was a plea of convenience. It would not have been a successful prosecution otherwise, Judge.
Okay, ordinarily, I would leave a no bond hold in place that's been set by a division judge, whether it's misdemeanor or felony. In this case, what I'll do is go on a brief recess. I will get in contact with Judge McHugh and see what she wants to do because I realize the reality of the circumstances we're in right now. We did have a meeting yesterday to discuss some of this with the county criminal judges, so if you will all just please give me a couple of minutes, I will call Mr. Giltonan back up in a few minutes. Just we'll go on a brief recess so I can get a hold of her.
Thank you, Judge. Thank
Your
you
Honor,
very
just
much.
so you know, I am in her division. She
Yes.
is actually having teleconference hearings today and every day after 10 o'clock.
That's fine. That's fine. I'll still get in contact with her. All right, we're gonna
Judge.
go on a brief recess. Yes.
Before you leave, I just, Mr. Clayman represents Ms. Vigilkowski on
Yes.
page 2 of the docket.
Okay.
He wonders if he can come in at 10:30 or if he can appear by phone.
I'll let him appear by phone. Just get a direct contact number for him, please.
Yes, ma'am, thank you.
All right, we're gonna go on a brief recess,
Thank you,
and I'll
Judge.
come back up in a few minutes.
Thank you. We're going to have a brief
All right, so let's bring Mr. Giltonan back up, please.
Your Honor, if you like, I can give you my copy of the probable cause affidavit. For
That's
the
all
new
right, not
case.
necessary. Okay, all right, Mr. Giltonan is back. Okay, Mr. Cohen, I've spoken with the division judge, and while I explained to you how we're gonna be handling these in the future, for the time being, since this does have a no bond hold on it, and Judge McHugh, I realize she's unavailable this morning because she's doing teleconferencing, but she is making herself available to do hearings. So I have to leave the no bond and hold for today, and you'll be able to contact her to get that hearing set as soon as
So
possible.
hopefully we can have the hearing tomorrow, so Mr. Gilton doesn't have to wait more than a day.
Correct, because
then,
I know
Judge?
that she's gonna be in, so if she's available, then she'll be able to hear it, but you'll just have to contact her office to do that,
All right,
okay?
I will do that. I have her email. Now, Mr. Gilton, don't talk about the case because anything you say can be used against you. All right, sir? What I'm going to be doing is I'm going to be contacting the judge's judicial assistant today to try to set a hearing for tomorrow morning at 10 o'clock so we can get you a bond. All right, sir?
Yes.
Okay,
Okay.
all right, thank you
I
very much.
just wanted to say, I don't have children with her. I raised two
Are
children by
those your own
myself.
two children, 8 and
Okay.
14?
I've been raising them for the last 6 years by myself, and currently she's moved out of the house I was made aware of yesterday. All her stuff is gone, so it's just me and my boys.
All right, Mr. Gilton, I appreciate that. We'll just get you a hearing in front of Judge McHugh, the trial judge, as soon as possible, sir.
Okay, all right.
Thank you.
Thank you, gentlemen, good luck, sir.
Thank you, Judge.
Thank you. All right, we also have a sign-in on page 15, Eduardo Saucedo. He has family present in the courtroom. Okay, good morning, Mr. Saucedo.
Good morning.
You are before the court this morning on 2 felony probation violations. I find probable cause, and Mr. Saucedo, these do have no bond holds on them, which means that you'll go in front of your division judge to address how those are going to be handled.
Okay.
All right, so that hearing will be set within the next few days, I'm sure. I know that the felony judges are working on getting a hearing docket set, so they're able to do them through this courtroom. So for the time being, the no bond holds will remain in place until you see that judge so they can tell you how it's gonna be handled, all right?
Thank you, ma'am.
Okay, you're very welcome. All right. All right, is there anyone else that needs to be called out of turn? All right, we'll continue down our list. Next will be Tarika Whitfield. Good morning, Ms. Whitfield.
Good morning.
Ms. Whitfield, you're before the court this morning on 3 charges. Count 1, aggravated battery with a deadly weapon, domestic violence. Count 2, criminal mischief greater than $1,000. And count 3 is a felony probation violation with a no bond hold. I find probable cause, and I will hear the parties' recommendations on count 1.
Judge, I spoke to Mr. Lender. I believe we have an agreement. Ms. Whitfield gave me the number of her mother who's going to post her bond. I'm going to be contacting her after court. We're going to be requesting $2,000 on count 1.
No objection from the state?
No, just with the, obviously, no victim contact order.
Yes. All right. So I will set the bond on count 1 at 2,000. The no bond hold will have to be addressed before your division judge, Ms. Whitfield. And there will be an order of no victim contact. And Ms. Whitfield, that means no being in the same place at the same time as the alleged victim, no phone calls or text messages to that person, no third-party contact or social media contact with that person. Do you understand?
Yes, ma'am.
All right, thank you. Next will be Nicole Fijkowski, and I will get Mr. Clayman on the phone. Thank you. All right, Ms. Fijkowski, I'm gonna get your attorney on the phone, so just give me one moment.
Okay. Thank you.
Good morning, Mr. Clayman. This is Judge Cawthon. How are you this morning?
Good morning, Your Honor. How are you?
I am well. We're trying to manage.
Thanks for
So,
letting me appear by phone. I do appreciate it.
all right, that's fine. I'm just gonna ask you to speak up a little bit because it's a little hard to hear you. I want to make sure everybody can hear.
Perfect.
right.
Can you hear me right now? Is
Yes,
this okay?
that's much better. All right, so I have
Great.
Ms. Fishkowski here. I'm just gonna read her charges. So Ms. Fishkowski, you're before the court this morning on 2 charges. Count 1 is aggravated stalking after a no contact order. Count 2, contempt of court where an offender has violated a no contact order. All right, and I will hear the parties' arguments and recommendations at this time.
The defendant was placed on pretrial supervision on February 16, 2020, in case number 201802 CF10A, 1 count of burglary of an unoccupied dwelling, 1 count of stalking, 1 count of resisting without violence. She was placed on pretrial with an electronic monitor, based on the court's finding of probable cause in today's new arrest. We're going to ask that her pretrial status be revoked at this time.
All right, Mr. Clayman, were you able to hear that?
Some of it. I think at the very end, the request was that she be held, if I heard correctly.
Pretrial is requesting that her pretrial services be revoked in the case she was set on pretrial in February.
Okay, so my request would be the following.
Go ahead.
Right now, it's obviously an interesting time period, and Ms. Wojciechowski does not have much of a criminal history at all. She hired me on the underlying burglary case. I did end up speaking with the alleged victim, and he has indicated to me on a couple of different conversations that it wasn't a burglary. Of course, that's not for Your Honor to really determine now, and that he doesn't want to pursue the offenses. With that being said, the defendant's father has been calling me over the past couple days where the individual who is the subject of a no contact order has repeatedly gone to Ms. Wojciechowski's house, is knocking on her door in her bedroom window, and is trying to engage with her. She understands very clearly now, and she's in custody and learning how this goes, that no matter what he does, she cannot have any contact with him. Based on her lack of criminal history and what's going on in the environment now, I would ask that Your Honor consider putting her back on pretrial, adding additional conditions. I will be candid with the court. When I spoke with the alleged victim in the case, he said the only thing that he wanted to see out of Ms. Wojciechowski was that she gets some type of anger management treatment. So whether or not that can even be accomplished right now with what's going on with the virus, I'm not sure if there are online courses or if there's an alternative that she can take, but I do think we can come up with a less restrictive measure. She's not a danger to the community. She's not a danger to him. He's relayed to me that he's not in fear of her. He just wants her to work on herself and try to figure out whatever's going on with her. And if Your Honor is not willing to do that, we could basically accomplish the same as keeping her in custody, putting her on level 1 house arrest, and just having her remain at home at her father's house.
Your Honor, I don't know that I agree that Ms. Fijolkowski is not a danger to the community. Shortly after her arrest in February on the charges that are pending, I imagine Mr. Clayman's aware of this, there was a stipulated agreement. BSO, Broward Sheriff's Office, sought and obtained a risk protection order against Ms. Fijolkowski. There was allegations of her owning and possessing firearms. So clearly, Broward Sheriff's Office had concerns for her safety and the safety of the public. Either Ms. Fijolkowski on her own or through counsel did not try to contest the order that Broward Sheriff's Office was seeking, and it was issued. She was already ROR'd last month and placed on a GPS monitor. So I'm going to be requesting a $10,000 bond on count 1. On the new charges, no victim contact, pretrial release of the GPS monitor.
Insofar as the bond, of course, I have no objection to that, Mr. Linderkin. I agree with it. That's totally fine. But insofar as the argument that she's a danger to society because of the risk protection order, I think there's a bit of conjecture there, respectfully to Mr. Linder. And that's natural whenever you have someone that's going to be enjoined from contact with someone. They can't possess firearms, weapons, ammunition, or anything of the like. But I do believe that we can keep Ms. Wojciechowski at home. She won't violate. And I am, like I said, I am working with the alleged victim in this case to come to a resolution.
So, Mr. Clayman, if she's placed on a level 1 GPS monitor, she can be at her father's residence?
She could stay with, can we inquire with Ms. Wojciechowski briefly, Your Honor? I spoke to the dad last night, and he didn't indicate that there was any issue with that. Can we, because I don't have her in front of me, can we ask her for the address and whether or not her dad wants her there? Because he stated to me that he does. I'd just like to hear it from
All
her.
right, Ms. Fijalkowski, can you hear Mr. Klayman?
Yes, I am.
All right, did you hear what he just said?
Yes.
Okay, are you able to go and reside at your father's residence if you're released?
Yes, ma'am.
Okay, you understand that if that happens, you would be placed under house arrest. That means that you're not to leave without any type of approval from your pretrial supervision officer.
Yes, ma'am.
All right, do you know the address?
Yes.
What's the address?
4339 Northwest 70th Lane, Coal Springs, Florida 33065.
Your Honor, can we relay how important it is that no matter what, no matter how many times he tries to contact her, he comes to the resident, he can do whatever he wants, she cannot engage.
Yes. All right, so what I'm gonna do is this. The case that was on pretrial, I'm going to place back on pretrial. I'm going to place the new case on pretrial. I'm gonna ask you what you need in just a minute, okay? That's going to be, and both of these cases are gonna have the same pretrial conditions. It's going to be a level 1 GPS monitor. She will effectively be on house arrest at her father's residence if pretrial is able to verify that information with her father. There, once again, will be an order of no victim contact. Ms. Fijalkowski, you have heard what Mr. Klayman has said. This order pertains to you, okay? It does not pertain to the alleged victim, it pertains to you. So no matter what the situation is, understand this means no being in the same place at the same time as this person, no phone calls to this person, no text messages to this person, no social media or email contact of any kind with this person, and no third-party contact. Do you understand that?
Yes, ma'am.
If you violate this again, we will be having a very different conversation next time. Do you understand that?
Yes, ma'am.
All right. There will also be an order in an abundance of caution that Ms. Fijalkowski possess no weapons, firearms, or ammunition. Ms. Fijalkowski, if you are in possession of any of those items, they are to be surrendered to local law enforcement until further order of the court. Do you understand that?
Yes, ma'am.
If the court is gonna not remove her from pretrial on
Yes.
the pending case, then we will take no action on that other case.
Okay.
And then on this case, is the court going to impose a bond?
Yes, I am on count. Thank you for reminding me. On count 1 in this case, as the parties have agreed, count 1 is going to be set at $10,000, and I will leave the $1,000 bond in place on count 2.
And then this
Thank
case, we're
you.
gonna put.
Your Honor, do you
Hold on.
require a phone number for pretrial services for her father?
No,
Okay, pretrial is
Okay.
telling me no, and what was the other request? I'm sorry.
I'm just saying, so that one, I'm writing level 1, and on this one, I'm writing no action.
Okay.
And we'll get it across.
Do you want me to sign
No,
this?
you don't have to sign it.
All right, there you go.
Thank you. No, we're not doing, this one is just bond and GPS.
Okay. All right, anything further from Mr. Klayman or Mr. Linder?
None from me. Thank you, Your Honor. Thank you, Mr. Linder.
All right, thank you, Mr. Klayman. Ms. Fijalkowski, good luck to you.
Have a
Thank you,
nice day.
appreciate it.
Thank you. All right, continuing on, next will be Lachey Dickerson. Thank you. Okay, good morning, Ms. Dickerson.
Hi.
Ms. Dickerson, you're before the court this morning on one charge of obstruction. I find probable cause, and I will hear from the parties.
Judge, this is a matter I discussed with Mr. Linder. We are asking for an ROR, and I do not believe he has an objection.
Mr. Linder, is that correct?
That's fine, Judge.
All right, Ms. Dickerson, I am going to ROR you, which means that you will be released today. However, I need you to understand that though you will be released today, that does not necessarily mean that's the end of the case. So it will be your responsibility to be in contact with your attorneys in the clerk's office so that you know about any future court dates you may need to be present for. Do you understand?
Yes.
All right, the deputy's giving you a piece of paper that has instructions on how you can do that. So make sure that you read that when we're done today.
All right.
All right, thank you, ma'am.
Thanks.
Next will be Michelle Brooks.
Ms. Broward advises she is a medical reset, Your Honor.
All right, thank you very much. Grace Johnson. Is she still a medical?
Also a medical reset, Judge.
Okay. Rebecca Selby.
Also a medical reset, Your Honor.
Jermaine Williams.
Me.
Okay. Good morning, Mr. Williams.
Yes.
Mr. Williams, you're before the court this morning on one charge of touch or strike battery, domestic violence. I find probable cause, and I will hear from the parties.
Your Honor, we have it on the $1,000 bond.
I'm sorry?
The $1,000 bond.
Okay. Mr. Romero?
That's what I talked to Mr. Williams. He advised me that his family will be able to afford that, so that's what we're asking.
All right, the bond will be set at $1,000. There will be an order of no victim contact. Mr. Williams, so that you understand the no victim contact order, with respect to the alleged victim in this case, that means no being in the same place at the same time as this person. If you reside together, that means that you will temporarily have to find someplace else to stay. The no contact order includes no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that, sir?
Yes, understood.
All right, thank you very much. Good luck.
All right, thank you.
Next will be Michael Tennant.
Judge, he's at Maine, and I spoke to him earlier this morning, and he declined the services of public defender.
All right, good morning, Mr. Tennant.
Good morning, Your Honor.
Mr. Tennant, do you understand that you're entitled to have an attorney represent you for this hearing this morning?
Yes, Your Honor.
And are you declining the services of the public defender at this time?
Yes, my friend's getting an attorney.
Okay, but I need you to understand, Mr. Tennant, that since you're entitled to have an attorney represent you today, you're entitled to have the public defender represent you for this hearing, and if you choose to hire private counsel later, then that is your right and your choice to do that. But if you decline the services of the public defender this morning, since you do not yet have private counsel, you would be representing yourself, which is fine, but I need to know that you understand your rights and what you would like to do.
Okay, I didn't understand that I could do both. I thought it was
Okay.
one or the other.
Okay?
But I have no choice but to represent myself now then, I guess.
You absolutely do have a choice. If you change your mind and you would like the public defender to represent you, that's fine. I will simply put your case on recall and give them a few minutes to speak to you over the phone before I call you back up and we proceed. Is that what you want to do?
Yes, please, Your Honor.
Okay, all right, Mr. Romero, I'll put him on
For
recall.
today? Is
Just
that
for
Your Honor?
today, correct, correct.
So I can go back on?
All right, so just sit down, they'll call you on the phone and I'll call you back up. Thank you. Next will be Marquise Jackson. Thank you. All right, good morning, Mr. Jackson.
Good morning, ma'am.
Mr. Jackson, you're before the court on an ad charge this morning. This is a misdemeanor violation of probation. I find probable cause. And Mr. Jackson, this has a no bond hold, which means that you'll go in front of your division judge so that you can address how that's going to be handled, all right?
Okay.
Thank you very much. Good luck, sir.
Thank you.
James Buis. I'm sorry? I didn't say a date. I didn't say a date. Yeah, I'm specifically not giving them dates for that reason. All right, good morning, Mr. Buis.
Good morning.
Mr. Buis, you're before the court this morning on a misdemeanor violation of probation. I find probable cause. And Mr. Buis, since this has a no bond hold, that means that you'll go in front of your division judge to address how that's going to be handled. All right, good luck to you, sir. Haley Richards.
Boy, they see all day now.
Good morning,
Good morning.
Mr.
How you
Richards.
doing, Judge?
I'm well, thank you, Mr. Richards. All right, Mr. Richards, you're before the court this morning on 2 charges. Count 1, touch or strike battery, domestic violence. Count 2 is a felony capias issued by your division judge, which has a no bond hold. I find probable cause, and I understand the no bond hold will have to be heard before the division judge, but I will hear the parties' recommendations on count one.
Judge, I believe we have an agreement on count one. I'm going to be requesting a $1,500 bond. I do not believe the state has any objection.
Okay, all right, so the bond on count one will be set at $1,500. Mr. Richards, there will be an order of no victim contact. So please understand, with respect to the alleged victim in this case, that means no being in the same place at the same time as this person, no phone calls or text messages to this person, and no third-party contact or social media contact with this person. Do you understand that?
Yes, ma'am.
All right, and with regard to the no bond hold, Mr. Richards, I'm sure you heard me say already, your division judge will be the one to address that, so you'll be seeing them shortly to handle it.
Shortly today?
It won't be today, sir. I'm not sure what the date is going to be yet, but you'll be getting notice of it soon. All right, they're working on it.
Appreciate it.
All right, thank you. Good luck. Next will be Patrick Nemhard.
With Broward, Your Honor.
Thank you. Good
Morning, ma'am.
Good morning, Mr. Nemhard. All right, Mr. Nemhard, you're before the court this morning on one charge of battery on a person 65 years of age or older. I find probable cause, and I will hear the parties' recommendations at this time.
I get to say something, that's what you mean?
Mr. Nemhard, just wait a few minutes. I'm going to hear from the attorneys, okay? So just listen.
Okay.
Your Honor, I'm requesting a $5,000 bond in order of no victim contact. It's based on the age of the alleged victim, his behavior that was described not only by his mother but also his father. Mr. Nemhard has a current order of protection out of the state of New York that was issued in May of 2019 and is in place until May of 2021. He does have a history of this. He does have a history of the state of New York. Disorderly conduct 2019. Not showing anything else, Judge. Nothing further.
Thank you. All right, Mr. Miller, I'll go to you.
Judge, I would just argue that the touching in this case is de minimis. Apparently, he pushed his mother into a chair. I don't believe she suffered any injury as a result of this touching. He is aware that there will be a no contact order going forward and is prepared to abide by that. He does have a place to stay that is separate and apart from the alleged victim in this case. He advises that he's been living in South Florida since about 1989. He works as an electrical technician, making about $500 a week. He also advises he's a registered voter. Judge, would the court consider a bond $1,000?
Your Honor, and I'm sorry, I just have to put this on the record. When your victim is 93 years old and suffering from breast cancer, I don't think there is such a thing as de minimis contact.
I gotta talk. I gotta talk.
All right, Mr. Nemhard, I don't want you to say anything about the facts of the case. We're only addressing bond and release conditions today. I've heard your attorney's recommendations, so just be patient and I will make a ruling in just a moment.
It's very important, Your Honor.
Mr. Nemhard, I do not want you to say anything about the facts of the case. That's not for today. All right, the bond in this case will be set at $3,500, and there will be an order of no victim contact. Mr. Nemhard, until further order of the court, please understand that the no contact order means no being in the same place at the same time as the alleged victim. That also includes no phone calls or text messages to this person and no third-party contact or social media contact with this person. Do you understand that?
Yes, ma'am.
All right, thank you very much, sir.
Ma'am, I would really like to say something, man. Say something that has nothing to do with the case.
Mr. Nemhard, you can discuss it with your attorney after we're done today. I don't want you to say anything on the record that's going to negatively impact your case.
Deputy, I'm going to call over now.
All right, Mr. Miller's going to call you on the phone to speak.
That they know I'm a 9/11 survivor, and all of that has
All right.
nothing to do with.
All right,
this
Mr.
whole
Miller will call you on the
9/11.
phone. You can speak to him privately. Thank you. Mr. Romero, are you ready for me to recall the other case? All right, let's go back to Maine. And we will recall Mr. Michael Tennant. Okay, all right, Mr. Tennant, I have you back here, and Mr. Romero has had a chance to speak to you. So, Mr. Tennant, for the record, you're before the court this morning on one charge of stalking. This is domestic violence. I find probable cause, and I will hear the parties' recommendations at this time. We'll begin with the state.
Your Honor, Mr. Tennant is from England. It doesn't show that he has been in Florida long, so we have no priors for him in Florida. Based on the allegations in this case, we will be asking for a $3,500 bond with a no victim contact.
Judge, we don't have an objection as far as a no victim contact. Mr. Tennant and the alleged victim do not live together. That's not going to be a problem. And speaking with Mr. Tennant, he does have ties to the community. He's advised me he's been living here in our community for 5.5 years. He's 49 years old. He works here. He works for a company that works on spas. He's been working for them for a number of years. He lives here locally in Miami, where he's been renting at the same location for the past 3 months. His monthly rent is approximately $1,600. Now, he does have no prior contact with the criminal justice system. So, Judge, on this case, I'm going to be asking for a $1,000 bond on his behalf, and I'm going to be asking you for a property order so he can have access to his property so he can self-bond, Judge.
Bond in this case will be set at $1,500. I will sign the property order. There will be an order of no victim contact. Mr. Tennant, it's very important for you to understand that that means with respect to the alleged victim in this case, no being in the same place at the same time as this person, no phone calls or text messages to this person, no social media contact, no email contact, no third-party contact. Do you understand? Will one of the deputies turn the speaker on so I can just hear from Mr. Tennant, please? Thank you.
Yes, Your Honor.
All right.
Yes.
Thank you very much, sir.
Thank you.
Thank you, Deputy.
All right. Next will be Santos Hernandez. I'm sorry? Yep.
Oh, Russia.
PM docket? Okay. All right. Ladies, will you hold that for her for the PM docket then? Thank you. All right, Emmanuel Alberto Carvajal.
No problem.
Thank you.
Hello.
All right, good morning, Mr. Carvajal.
Good morning. How are you today?
I'm well, thank you. Mr. Carvajal, you're before the court this morning on 8 charges. Count 1, DUI, alcohol or drugs. Counts 2, 3, 4, and 5 are each a separate count of DUI with damage to property or person of another. Count 6, careless driving. Count 7, failure to carry or exhibit a license. And count 8, failure to provide proof of current insurance. Counts 6 and 7 are not for magistrate. I find probable cause, and I will hear the parties' recommendations at
Your Honor,
this time.
defense is requesting the bonds be kept as set.
State,
Sorry, I'm sorry, what was the request?
standard bonds.
Bonds be kept as set? Yeah, I'm fine with that.
Okay, all right, I will leave the standard bonds in place at this time. Thank you. Off. Completely? Okay, all right, we're gonna take just a very, very brief recess. I'll be right back. Okay, all right, we're back. Next will be Adrian Brown.
I believe he refused again.
No problem. Med reset.
Is he a reset or a refusal?
I'm sorry, refusal.
Okay, Mr. Brown, I gave him, this was the one I believe that he was a refusal yesterday, and I said I was gonna reset him one more time or proceed without him.
Objection, Your Honor.
All right, I'm going to make a finding of probable cause in absentia, and if there are no objections from the parties, I'll leave the standard bond in place on count one.
No objection, Your Honor.
Nothing further?
All right, thank you. Okay, next will be Henok Dujust. Is he at me? Thank you.
Speak to him.
All right, good morning, Mr. Dujust.
Good morning.
Mr. Dujust, you are here this morning on 5 ad charges. Count 6 is for grand theft, 7, fraud uttering a false instrument, 8 is fraud, use or possession of ID of another person without consent, and counts 9 and 10 are felony probation violations which have no bond holds. I find probable cause, and in light of the no bond holds on counts 9 and 10, do the parties have anything to add on the other counts?
No, Judge.
Not at this time.
All right, so I will leave the standard bonds in place on those items. All right, thank you very much, Mr. Jujos. Good luck to you, sir.
All right, thanks.
Rudolph Jean Baptiste.
Jean Baptiste.
Conti, Judge.
Thank you.
Good morning, Your Honor.
Good morning, Mr. Jean Baptiste. All right, sir, you're here today on 2 ad charges. Count 1 is retail theft greater than $750 while coordinating with others. Count 14 is a felony probation violation which has a no bond hold. I find probable cause, and in light of the no bond hold, do the parties wish to be heard on the retail theft charge?
No, Judge.
Not at this time, Judge.
All right, I will leave the standard bond in place on that charge. Okay? Mr. Jean Baptiste, good luck to you, sir.
Thank you, Your Honor.
Thank you. Daniel Arroyo.
T, Judge.
Good morning, Mr. Arroyo.
Good morning.
Mr. Arroyo, you're before the court this morning on an ad charge. This is an additional charge for shooting at or into an occupied vehicle. I find probable cause, and I will hear the parties' recommendations. We'll begin with the state.
Yes, Your Honor, Mr. Arroyo, his other charges are he's got a no bond on a robbery firearm, $10,000 each on 2 counts of aggravated assault with a firearm, and a $50,000 bond on another robbery firearm. I'd be requesting a $10,000 bond on this charge.
All right. In light of that, I will set the bond on this count at $10,000. All right, thank you, Mr. Arroyo. Good luck, sir. Michael Grace. Good morning, Mr. Grace.
Good morning.
Mr. Grace, you're here this morning on 2 ad charges. Count 2 is for burglary of an unoccupied conveyance unarmed. Count 3 is for grand theft. I find probable cause, and I will hear the parties' recommendations at this time. We'll begin with the state.
Your Honor, requesting a $5,000 bond. Count 1, he's being held no bond on an armed home invasion.
Without objection, Your Honor.
All right, then I will set the bond on count 2 at $5,000, and I will leave the $1,000 bond in place on count 3. All right, thank you, Mr. Grace. Good luck, sir. Brian Davis.
Your Honor,
Yes.
you called
I'm sorry?
me. You need someone?
Brian Davis. Where's Mr. Davis? Is he at Conti? Okay.
1 second. He's talking to an attorney. I'm going to get him right now.
Okay, thank you.
the last thing you saw on him?
Your Honor, while we're in a lull, can I request a medical screening for Patrick Nimbard?
That's fine.
Thank you.
Here is Your Honor.
Thank you. Good morning, Mr. Davis.
Good morning, ma'am.
Mr. Davis, you're here this morning on an ad charge. This is for an immigration hold.
Yes, ma'am.
All right, I find probable cause. And Mr. Davis, since this has a no bond hold on it, that means that you'll go before an immigration judge in order to address this matter.
Yes, ma'am. I was just recently speaking with an immigration officer a moment ago.
Okay.
And they said, based on if I'm bonded out or if I'm released on my own recognizance, they would come and get me. But I would have to be released from this facility in order for them to. So it's either some type of release. I would have to be released from this facility at some point.
So, Mr. Davis, I understand exactly what you're saying to me, but since the immigration hold is the only thing that's in front of me today, I'm not able to address what's holding you on your other charges, but your division judge will be able to do that. So if you have an assigned attorney already, speak to that attorney and they'll prepare the appropriate motion if that's necessary.
I do not have enough. I'm sorry.
That's
I'm kind
okay.
of new to this. So I haven't spoken to an attorney. I have not been assigned an attorney as of yet. So I'm asking.
Did you sign up with the public defender's office?
I didn't get this. I haven't signed anything as yet. No, ma'am. I haven't. When I got arrested here, I went to a magistrate court on Saturday.
Right.
They gave me a ROR on one charge. They gave me $1,000 bond on another charge.
Right.
I was in process of trying to bond out.
Right.
I realize now that I have an immigration hold, so I've had a few friends of mine trying to get me a bond out.
Okay.
So I don't know what would be the best step, but I just spoke to the immigration officer. He said I have to be released here at some point. So it's either you can ROR me or I can get a bond out, but I just have to be released from
hold
here.
on 1 second. Let me ask my confinement rep something. If he has someone post that $1,000 bond, then will they come pick him up on the immigration hold? Yes, okay. So, Mr. Davis, if you have friends that are able to post that $1,000 bond for you, once that bond is posted, then they'll be able to come pick you up for the immigration issue, and you'll go address that, okay?
Okay. I was just trying to speed up the process.
Okay.
Maybe a bit better.
I know, but Mr. Davis, I can't change that $1,000 bond today. So if they're able to post it, then that's what'll happen, just so you know, okay?
Thank you so much.
All right, you're welcome. Good luck.
All right.
Okay, next will be DeAndre Dozier.
Bonded.
Thank you. Guy Romaine.
Judge, he's at Maine, and after speaking to him, he advised me per his term he's proceeding pro se.
All right. Good morning, Mr. Romaine.
Good morning, Your Honor.
Mr. Romaine, before we proceed, I just need to ask you a couple questions.
Yes.
First off, do you understand that you are entitled to have an attorney represent you for this hearing?
Yes, I do.
Okay. And are you declining the the services of the public defender at this time?
Yes, I am.
All right.
Okay.
Okay, that's okay. All right, I just need to make sure you understand. Okay. So, Mr. Romaine, you're before the court this morning on 2 charges. Count 1, battery on an officer, firefighter, or EMT. Count 2 is possession of a blank or fictitious driver's license. I find probable cause, and to begin, I will hear the state's recommendation as to bond and release conditions.
Seeking a $1,500 bond on count 1, Judge.
All right. So, Mr. Romaine, as of right now, you have a $1,000 bond on count 2.
Can I?
Hold on, I'm
Okay,
listen.
okay.
I'm going to ask you a question in just a minute. So the state is recommending a $1,500 bond on count 1, and you have a $1,000 bond on count 2. Do you understand?
Yes.
Okay. Are you the one that's going to be posting your own bond, or are you having someone else post that for you?
Well, what I wanted to tell you is what you had stated. There was no paramedic or officer. It was a parking meter
person when I was working doing Uber Delivery Eats, and I had just
Okay,
arrived.
hold
They
on,
had
hold
just
on,
arrived.
hold on, Mr. Romaine, hold
Okay.
on, okay? I don't want, because this is just your bond hearing, I don't want you to say anything about the background or facts of the case. We're only
Okay, well,
talking
my
about.
financial situation is they impounded my vehicle, which I work with. I rent out a vehicle through a rideshare program of $1,300 a month.
Okay.
I work every day, and I can show how much I make money with Uber Eats. But the problem is, they've impounded my vehicle. I am in a homeless situation. I've been working. I got a bank account. I have storage, but I live in the car instead of shelters.
Okay.
And I work every day. I have a young boy in Costa Rica, 8 years old. That's straight honors. I homeschooled him when I was there in Costa Rica and everything. And I send money over there all the time. I've got bills I'm trying to pay, and I'm also working to getting myself out of this situation completely. Not very close to that, except for this crisis that took place. And the
Okay.
thing that I'm just saying is that I was working, and this
Okay,
is an
hold on, I
emergency
don't
crisis.
want, don't say
Okay,
anything about the
okay.
facts, we're just talking about the bond, okay?
I can't afford anything right now because of the fact that my income and right now is accruing that they put it in the pound, and that's what I live in and that's what I work with. And then every day I pay $48 for my vehicle, right? And every day I work and I make sure I got gas, I got food, I got my bills I can pay and all that stuff. So I'm hard working. I did this situation, like I said, but I'm not gonna go into all
Yeah,
that.
I
because
don't
we're
want
not
you
here
to
for
talk
that.
about that. So you're telling me that you can't afford to post any monetary bond at all? Is that what you're saying?
No, ma'am, because right now, as of yesterday, they don't know what happened to me as far as I wasn't able to make a call. So the page for the vehicle through the rideshare program, because the owner that has it through the rideshare program, I paid through that. That covers insurance and everything like that. So I've already missed a day, and then it's accruing and accruing and accruing
Okay.
right now. And that's my income is working with my vehicle every day. You know what I'm saying?
Okay.
And I work really hard. So
All right, I
this
understand.
is really
Okay, so just give me a moment. Now I'm just gonna ask the state a couple questions. Mr. Linder, are you showing any prior history for Mr. Romaine?
Yes, Judge.
Okay, go ahead.
Texas, Illinois, Colorado.
What's the most recent?
2017.
Mhm.
And that was completely, I've defended
Okay,
myself, and that was
hold on,
complete.
Mr. Romaine, hang on.
There's no
Mr.
conviction on my
Romaine,
part.
I just need
Oh,
you
okay,
to,
okay.
I'm listening to Mr. Linder right now,
Okay.
just one at a time,
All right.
please.
There's none of those I have no
All right,
conviction
Mr.
for any of that.
Romaine, just a moment,
Okay.
please. Okay, Mr. Linder, go ahead.
Last arrest I see was in Texas, 2017, for child neglect. Charges.
That's not true. That's not true.
Mr.
And I have
Romaine, Mr. Romaine,
Okay.
please.
I'm sorry.
If you
I'm sorry, but I'm just
continue,
saying.
you're not doing anything to help yourself right now,
All
okay?
right,
So
all
just
right, I just
listen.
Your Honor, it says family neglect. It would appear that it's a child neglect type situation. The charges were dropped.
Mhm.
Let's see.
Okay, that was 2017, you said?
Yes, Judge.
Okay.
Yes, because I was living in Costa Rica the past 14 years.
All right, Mr. Romaine.
Okay, all right. But I'm just saying, I have all the
Mr.
transcripts in my car.
Romaine, all right. Okay.
Dated theft out of Colorado. Also advised the court on his FBI NCIC. Michael Wright is a listed alias, and he was found to have an ID in that name.
Right, they know about this. I've been to court, federal court.
All right. So what I'm gonna do is this. On count 1, the bond is gonna be set at $1,000, and on count 2, I'm gonna reduce that to $500. All right?
Okay.
All right.
Okay.
Thank you, Mr. Romaine.
All right, thank you.
Joseph Dawson.
All right.
All right, good morning, Mr. Dawson.
Good morning.
Mr. Dawson, you're before the court on 3 charges. Count 1, possession of heroin. Count 2, driving while license suspended. Count 3 is a misdemeanor capias for driving with an expired driver's license over 6 months. I find probable cause, and I will hear from the parties.
Judge, I believe we have an understanding with the state.
Okay.
I'm going to be asking for Mr. Dawson to be released on non-monetary conditions. I don't think the state has an objection to that.
What are the conditions?
ROR, Judge. Pre-trial. ROR to pre-trial.
Judge, we agreed to pre-trial with Raina Pesky.
Okay. All right, so, I'll place the capias that has the $2,000 bond, I'm gonna add to that. So I'm going to place an ROR on counts 1 and 3. And Mr. Dawson, you're going to be placed on pretrial supervision. You will be subjected to random drug and alcohol testing. So that means no alcohol and no intoxicants until further order of the court. Do you understand that?
Yep.
All right, additionally, though you're going to be released today, you must report to pretrial supervision within 24 hours. If you fail to report to pretrial, as I've instructed you, a warrant will be issued for your arrest. Do you understand that?
Yes, I do.
All right, one of the deputies is going to give you a piece of paper that will have information on where to go and instructions for reporting, so make sure you read that when we're done here, okay?
Thank you.
All right, you're welcome. Good luck. Anthony Williams. Good morning, Mr. Williams.
Good morning.
Mr. Williams, you're before the court on 7 charges. Counts 1, 2, 3, and 4 are felony warrants for violations of pretrial. Those have no bond holds. Count 5 is aggravated assault with a deadly weapon without intent to kill. Count 6, aggravated battery with a deadly weapon. Count 7, aggravated battery on a person over 65 years of age. I find probable cause, and in light of the no bond holds, do the parties wish to be heard?
The only thing I would ask, Your Honor, is that the court also impose the special release conditions that Judge Usan set on the warrant.
All right, I do see with respect to counts 5, 6, and 7, he's got a pretrial supervision with a level 1 GPS monitor, no weapons, firearms, or ammunition, no victim contact, and that will include a 1,500-foot stay away from the victim. Let me just ask pretrial, do you need me to write out each of those on here? Okay. Okay. All right, so Mr. Williams, I just need to advise you that right now you have those no bond holds, which will be addressed with your division judge. If you do become eligible for release and you post your monetary bonds, you will be placed on pretrial supervision with a level 1 GPS monitor. There will be an order of no victim contact, and that will include a 1,500-foot stay-away order from the alleged victim in this case. Since you'll be wearing a GPS monitor, that means that it will be tracking you and you cannot be within 1,500 feet of the victim. That no contact order includes no phone calls or text messages with that person, and no third-party contact or social media contact with that person. Do you understand that?
Yes, ma'am.
Okay. There's also going to be an order that you possess no weapons, firearms, or ammunition. So if you are in possession of any of those items, they are to be surrendered to local law enforcement until further order of the court. Do you understand that?
Yes, ma'am.
All right. Thank you very much, sir. Good luck. Carl Biggs. Thank you. Good morning, Mr. Biggs.
Good morning.
All right, Mr. Biggs, you're before the court on 1 charge of failure to comply with the sex offender registration law. I find probable cause, and I will hear from the parties at this time.
Judge, I spoke with Mr. Lender. I believe we've agreed on a monetary bond of $2,000. Mr. Biggs did advise me that his son, who lives in West Avey, can go ahead and post that for him.
Any objection, Mr. Linder?
No, Judge.
All right, then the bond will be set at $2,000. All right, thank you, Mr. Biggs. Good luck, sir.
Thank you.
Stephen Dimitruk.
How you doing, man?
I'm well, thank you, Mr. Dimitruk. All right, sir, you're before the court this morning on a felony violation of probation. I find probable cause, and Mr. Dimitruk, since this has a no bond hold on it, that means that you'll go in front of your division judge to address that matter and how it's gonna be handled.
Is there any way I could bond out because I got a
Not
1.5-year-old
Mr. Dimitruk,
daughter?
right now it has a no bond hold on it, and I do not have the ability to lift that. You'll go in front of your division judge soon so that that judge can address how to handle it, okay?
How long do you think that would be? Because I gotta get out. I got a family and stuff.
I don't have a court date to tell you right now, but all I can say is it'll be soon. They're working on it. All right, good luck, sir. Freddie Jordan. Okay, good morning, Mr. Jordan.
Good morning, ma'am.
All right, Mr. Jordan, you were here this morning on 6 charges. Count 1 and count 2 are each a separate count of possession of a weapon or ammunition by a convicted U.S. felon. Count 3, possession of cocaine. Count 4, possession of cannabis greater than 20 grams. Counts 5 and 6 are each a separate count of distributing or delivering PVP. I find probable cause, and I will hear from the parties at this time.
Your Honor, on counts 1 and 2, I'd be requesting a $5,000 bond on count 1, $1,500 bond on 2. Mr. Jordan, could you see if he has anything else? One moment, Your Honor, I'm showing 2015 possession of cannabis, 07 possession of cocaine with intent with a VOP, 02 possession of cocaine with intent, criminal mischief 02, DUI 2000, 2 separate deliveries of cocaine in 97, VOP, year in a day state prison. I'm also showing at least 2 prior failures to appear.
All right, Mr. Romero, we'll go to you.
Judge, specifically on counts 5 and 6, as you can see, there's a $35,000 bond on each of them, $70,000. Mr. Jordan advised me that's something he nor his family can afford to post. Now, he's been here his whole life. He's 42. He has his own business. He's has his own landscaping business, been doing that for about 10 years now. He lives in Fort Lauderdale with his aunt. His aunt is retired on a fixed income. The person that's going to help post his bond is his girlfriend, who's a waitress. And from what he advised me right now, with the situation, her work has been affected. So they do have limited financial resources from what he advised me. At most, using the services of bondsman, he's going to be able to come up with about a $10,000 bond. So what I was going to ask the court to consider is on counts 1 and 2, a $1,000 bond on each of those offenses. I'm going to ask for a bond reduction on counts 5 and 6. I'm asking for a bond reduction of $2,500 on each count, Judge. So if my math is correct, that's going to be 5, 6, 7, 8, 9. $9,000 bond is what we're requesting, Judge.
All right, on counts 1 and 2, I will set the bonds at $1,000 for each of those counts. With respect to counts 5 and 6, because those bonds were put in place by Judge Uson, I'm not going to modify them at this time. So the bonds on counts 3 through 6 will remain in place as set at this time. All right. Good luck, Mr. Jordan.
Thank you.
Terrence Turner.
Thank you. I'm sorry. North Broward, Judge.
Okay, all right. Good morning, Mr. Turner.
Good morning.
Mr. Turner, you're before the court this morning on 1 charge of burglary of an occupied dwelling, unarmed. I find probable cause, and I will hear from the parties.
Can you give me what, ma'am? I couldn't quite hear that.
Mr. Turner, just one moment. I'm waiting to hear from the attorneys with their recommendations. Just hang on.
Okay.
Your Honor, I'm going to be requesting that the court keep the bond that Judge Porth set in place. Should Mr. Turner post that bond, pretrial release of the GPS monitor, no victim contact, no return? First off, Mr. Turner has an open possession of cocaine out of Lee County, criminal mischief out of Leon County.
I've been making an appearance.
Mr. Turner, just one moment, okay? This isn't a time for you to talk, just listen.
He's been to state prison in Florida for possession of firearm ammunition by a convicted felon, grand theft auto, aggravated battery with a deadly weapon, battery on a law enforcement officer, possession of cocaine. He also has federal priors for 2010 possession of firearm by convicted felon, sentenced to 90 months in federal prison. He had a probation violation in 2018 and was sentenced to an additional 14 months in federal prison. And also in 2010, federal prior of unlawful transportation of firearms.
Ma'am, Your Honor.
Mr. Turner, just one moment, please. I have your attorney here in the courtroom with me. I'm going to hear from him.
Okay.
All right, go ahead, Mr. Miller.
Your Honor, Mr. Turner advises that he has been living in South Florida his entire life. Current address for about 5 years. He works odd jobs and is currently applying for Social Security disability. He is relying on his family for support. He does have a place to stay when he gets out. We're asking the court to set the bond at $5,000.
Would I be able to? Can I talk?
All right.
Speak to you privately, sir.
Mr. Turner, do you need more time to speak with your attorney privately?
I would love to be able to
Thank you, Judge.
privately.
All right, I'm going to put you on a brief recall, and Mr. Miller's going to call you on the phone so you can speak to him privately. Okay?
And when is?
Go ahead. He's calling you right now.
All right. Thank you.
Is Dobbins at Maine? All right, I'll go ahead and go to him. Let's go to Maine and call Michael Dobbins.
It's good to know that it's there. Because people are bleeding and they don't get it.
Good morning, Mr. Dobbins.
Good morning.
Mr. Dobbins, you're before the court on one charge of aggravated battery with a deadly weapon. I find probable cause, and I will hear the parties' recommendations at this time. Okay.
Your Honor, I'm requesting a $5,000 bond based on the allegations that Mr. Dobbins used a pickaxe to attack the victim. I'm showing priors out of D.C. and Georgia. They are dated, though.
All right.
They appear to be drug-related.
All right, Mr. Romero, I'll go to you.
Judge, Mr. Dominus did tell me he had priors that were quite dated. He is working now. He works for a health center. He's currently working right now. His job has not been affected. He's part of the crew that maintains the cleanliness of that center. So I would say his job is quite vital at this time. Now he's living in Miami by himself where he rents a room. He's been residing in the same place for 10 years. He's 56 years old. Judge, he's out there trying to help his mom. His mom lives at a senior living facility. Judge, and speaking Mr. Dobbins, I did have to advise him that today we're here for the purposes of establishing release conditions, but he wants to fight this case. Judge, my understanding is that nobody is going to be able to help post his monetary bond. We're asking for the court to consider releasing him on pretrial release.
All right. I'm concerned with respect to the allegations in the probable cause affidavit. It appears that this incident was witnessed by a Broward County Sheriff's Sergeant, and the alleged victim in the case did have to be transported to the hospital as a result of the injuries that were sustained. So I'm not comfortable with a straight release to pretrial at this time.
Can I say something?
Mr. Dobbins, you can't say anything about the facts of the case. I'm only addressing bond and release conditions. Do you understand that? Okay.
Judge, I would say he does, he wanted me to talk to me, he actually spoke to me about the facts of the case, and I believe that's what he wants to talk about. I told him today's not the day, but the one thing I want to stress to the court is, I believe his last contact was over 10 years ago. So Judge, right now no one can afford to post his bond, so that's why I'm asking for pretrial.
I understand the request, but based on the nature of the allegations, I'm going to respectfully deny the request. The bond is going to be set at $3,000. There is going to be an order of no victim contact. Mr. Dobbins, whether you know the alleged victim or not, please understand the no contact order means no being in the same place at the same time as this person, no phone calls or text messages to this person, no third-party contact or social media contact with this person. Do you understand that?
Yes.
All right. Additionally, there is going to be an order that you possess no weapons, firearms, or ammunition. That means if you are in possession of any of those items, they are to be surrendered to local law enforcement until further order of the court. Do you understand?
Yes.
All right. Thank you, Mr. Dobbins. Good luck to you, sir. Okay. Mr. Miller, are you ready for me to go back to North Broward?
I am, Your Honor.
All right. Let's go back to North Broward on Mr. Turner's case. Mr. Miller's.
So I did speak with Mr. Turner further. He wants to advise the court that he is a full-time student at Purdue University Global, that he is not a flight risk. He does not object to level 2 supervision or random testing. And we're just renewing our request for the bond to be set at $5,000.
All right. I appreciate the request and the further information. In this case, since Judge Porth is the one that set the bond, I am going to leave that bond in place as set. If it needs to be modified, that can be addressed with the division judge. If Mr. Turner does post his monetary bond, he will be placed on pretrial supervision with a level 2 GPS monitor. There will also be an order of no victim contact and no return. Mr. Turner, that means you are not to be in the same place at the same time as the alleged victim. No phone calls or text messages to this person. No third-party contact or social media contact. No returning to the location of the incident in this case. Do you understand?
Yes, ma'am.
All right. There will also be an order that you possess no weapons, firearms, or ammunition. If you are in possession of any of those items, they are to be surrendered to local law enforcement until further order of the court. Do you understand?
Yes, ma'am.
All right. Thank you very much, sir. Good luck. Next will be Giovanni Joseph. Maine? Thank you. Good morning, Mr. Joseph.
Good morning.
Mr. Joseph, you're before the court this morning on 3 charges. These are each a separate count for a felony violation of probation. I find probable cause. And Mr. Joseph, since these have no bond holds, that means that you'll go before your division judge in order to address this matter. Right.
Can I ask you one thing, ma'am?
Yes, sir.
I was on probation. It's just I did not show up to do a urine test. I was running late. So my probation officer violated me with not showing up to do my urine. That's why I'm here for it. But
okay. Well, Mr. Joseph, I understand what you're telling me, but you're going to have a hearing soon in front of your division judge, and so that's the person that you'll need to tell that to, because I don't have the ability to lift the no bond hold this morning, okay?
All right, would that be today, tomorrow, next week?
It's not going to be today. It will probably be within the next few days. Okay, so you'll get
All
notice
right.
as soon as that hearing is set, okay?
All right, thank you.
Thank you. Next will be Barry Harden. Good morning, Mr. Harden.
Good morning.
Mr. Harden, you're before the court this morning on 2 charges. Count 1, robbery with a firearm. Count 2, wearing a mask while committing a second-degree felony. I find probable cause, and I will hear from the parties, beginning with the state at this time.
The state would be seeking a finding of proof evident or presumption great on count 1. Request that Mr. Harden be held no bond at this point in time, relying upon the probable cause affidavit from Detective Sokol.
Thank you. Mr. Miller?
Your Honor, aside from objecting to the court finding proof evident presumption great based solely on a probable cause affidavit, I have no argument to make, and we will reserve any future conversation for another day.
All right. Thank you, sir.
And I should have mentioned, in light of count 1, I have no objection with ROR on count 2.
All right, based on the information provided in the probable cause affidavit, at this time, the court is going to make a preliminary finding of proof evident presumption great in order that Mr. Harden be held no bond on count 1. That will be without prejudice for him to have the appropriate Arthur hearing before his division judge. In an abundance of caution, I am also going to ensure an order of no victim contact as well as a no return order. Mr. Harden, please understand that whether you know the alleged victim or not in this case, the no contact order means no being in the same place at the same time as this person, no phone calls or text messages to this person, and no social media contact or third-party contact. The no return order means that you are not to go to the location of incident in this case. Do you understand what I've explained to you?
Yes, ma'am.
All right, thank you very much, sir. Good luck. Next will be Leonard McKenzie. Good morning, Mr. McKenzie.
Morning, Your Honor.
Mr. McKenzie, you're before the court this morning on 4 charges. Count 1, robbery with a firearm. Count 2, wearing a mask while committing a second-degree felony. Count 3, possession of a weapon or ammunition by a convicted Florida felon. Count 4, resisting an officer obstructing without violence. I find probable cause, and I'll hear from the parties, beginning with the state.
Your Honor, same argument that I made for Mr. Harden. I'm fine with an ROR on count 2, requesting a $5,000 bond on count 3.
All right, Mr. Miller, we'll go to you.
Again, aside from objecting to the court finding proof evident presumption great based solely on a probable cause affidavit, I have nothing to add to the conversation at this time.
All right, thank you very much. Okay. Based on the information in the probable cause affidavit, the court's going to make a preliminary finding of proof evident presumption great in order that Mr. McKenzie be held no bond on count 1. That will be without prejudice for him to have the appropriate Arthur hearing before his division judge. Count 2 will be an ROR. Count 3, the bond will be set at $5,000. And once again, in an abundance of caution, there will be an order of no victim contact as well as a no return order. Mr. McKenzie, so that you understand those orders, whether you know the alleged victim or not, that means no being in the same place at the same time as this person, no going to the location that's at issue in this case, no phone calls or text messages to the alleged victim, and no third-party contact or social media contact with that person. Do you understand?
Yes.
All right, thank you very much. Good luck, sir. John Vermont.
Why is he bonded?
All right. Thank you. James Ash.
Maine.
Good morning, Mr. Ash.
Good morning, y'all. Good morning.
All right, Mr. Ash, you're before the court on 3 charges. Count 1, use or display of a firearm during a felony. Count 2, possession with intent to sell, manufacture, or deliver cannabis. Count 3, possession of cannabis over 20 grams. I find probable cause, and I will hear from the parties.
Your Honor, I'm requesting a $1,500 bond on count 1. It's based on the totality of the circumstances, the contraband that was found, and the amount of cash that was also found.
Okay?
What was the state's request on count 1?
1,500.
1,500? Judge, no objection with count 1, 1,500. I'm going to be asking, however, on count 3, the cannabis offense, felony cannabis offense, if the court would consider an ROR on that count.
Again, Your Honor, based on everything that was found, I think a total bond of $3,500 is pretty reasonable.
All right, the bond on count 1 will be set at 1,500, and I'm gonna leave the standard bonds in place on counts 2 and 3. All right, thank you, Mr. Ash. Good luck, sir.
Yes, ma'am. Thank you.
Albert Myers.
Roaching.
Good morning, Mr. Myers.
Good morning, ma'am.
Mr. Myers, you're before the court on 2 charges. Count 1, possession of cocaine. Count 2, possession of cannabis, 20 grams or less. I find probable cause, and I'll hear from the parties.
Judge, in speaking to Mr. Myers, he advised me that he can post the bond. He gave me the phone number of his friend. I asked him if he's 100% sure that his friend will be able to post his bond. He said no problem, so nothing to request at this time.
Okay, anything from the state? All right, so I will leave the standard bond in place at this time. Good luck, Mr. Myers. Jeffrey Andrews.
That's a medical reset, Judge.
All right, thank you. That brings us to the end of our morning docket for first appearances. Our afternoon session will begin with Judge Lerner Wren at 1 o'clock today. Thank you.